My presentation today is about the benefits of EU and Vietnam provisions on geographical indications. First, I would like to provide some basic information on the EU-Vietnam FTA, or in short, EVFTA. This FTA was signed on the 13th June 2019 in Hanoi, and the effective date to Vietnam is the 1st August 2020. The IP chapters had 63 articles, in which GI is referred in the subsection 3 with 11 articles. Besides the IP chapters, there are also two annexes related to the GI provisions. First, the Annex 12A refers to the list of GIs divided into Part A with 169 European GIs and Part B with the 39 GI of Vietnam. And second is the Annex 12B refer to the product classes of those GIs. Here is an overview of the 11 articles of GIs in the IP chapter. As you can see, compared to other IP objects, GI section is covered rather broad areas, from the scope of application, which applies to the recognition, protection of GI for wine, spirits, agricultural products, and foodstuff, which are originating in EU and Vietnam. Then the system of registration, the list of GI, the mechanism of amendment of the list, the level of protection, the exceptions for some special GIs, and as well as the cooperation on all matters of GI in this section. Specifically, this section has its own article of enforcement beside the enforcement section, which I will refer to it afterward. We have to say that this is the first time we have a kind of list of GI which are protected throughout an FTA. And all GI, whatever agricultural products, foodstuff, etc., all enjoy the same high level of protection as wine and spirits in TRIPS agreement. And as you already know that in TRIPS, there are two levels of protection applied to GI, in which wine and spirits enjoy additional protection in Article 23, which to prevent the use of GI in translation or accompanied by expressions such as Kai, type, style, or the like. And when Vietnam accepts the WTO, the domestic law was built on the same spirit, in which it's also provided two levels of protection, one for wine, spirit, and the other for all the other remaining GIs. Basically, from the slide, you can see through this quick statistic that the EU GI products and Vietnam GI products are actually supplemented to each other rather than competed to each other. For example, from the EU side, more than half of EU GI are wines, which is 50.8%, followed by the spirit, 13.6%, and then cheese, 11.8%, etc. And for Vietnamese side, more than half of the Vietnam GI are fruit and nuts, which is 51.2%, including some like dragon fruits, pomelo, orange, lychees, mangoes, banana, etc. Followed by the spices, which is 70.8%, including cinnamon, star anise, also including tea or coffee beans. And cereal, 10%, which is basically the rice. And the famous Vietnamese nước mắm, we have Phu Quoc and Phan Thiết, which is 5%. Throughout the GI provisions in EVFTA, I will here refer just only some of the outstanding provisions in which either our domestic regulations are silent or still lacking of. And one of those is the homonymous GIs. In the EVFTA, the homonymous GIs, along with TRIPS, require a party to decide practical conditions of use in which homonymous GI will be differentiated from each other. The homonymous GI which mislead consumer basically shall not be registered. And with that requirement, in case of negotiating with the third countries to seek the protection of homonymous GI to EU GI, for example, Vietnam shall have to inform and give the opportunity to comment about the protection. And in fact, with EU GI, we haven't had any cases with homonymous GI registered, so we have to admit that we don't have much practical experience on dealing with that. Except for the other party, we have some experience like the Pisco, maybe all knew that the Pisco GI Peru and Chile. But however, this is kind of regulation and requirement are require the Vietnamese to change law to bring all the regulation to the domestic law. The second issues I want to present here is the exception provisions of EVFTA. In EVFTA, there are two groups of exceptions. The group one, the exception of using indication related to cheese, namely Asiago, Fontina, Gorgonzola of Italy, and Feta from Greece. And the group two is indication for wine Champagne of France. These exceptions was used beyond the fact that for the group one, many companies of Vietnam's trade partners already did and are continuing export to Vietnam the cheese product, which in their countries, these indication being considered as a generic name of cheese. For example, the Asiago cheese, Fontina cheese, Feta cheese, from some American companies such as Belgiosol or Arthur Schumann or Santori. And for the group two, based on the fact that the champagne indication in Vietnam basically refer to a kind of sparkling wines as a generic name, and we use this kind of sparkling wines for the New Year festival, and mostly all the sparkling wine, champagne is imported from Russia, and we use in every taste family, taste festival. So here it's the regulation of the group one, the cheese, Asiago, Fontina, and Gorgonzola. The text of EVFTA read as follows: the protection of these GI shall not prevent the use of any disease indication in the territory of Vietnam by any persons who may actually commercial use in good faith of those indications with regard to the product in the class of cheese prior to the 1st January of 2017. In fact, as referred above, recently we received some requests of clarification from the U.S. Dairy Export Council related to the use of Asiago, Fontina, and Gorgonzola for their products of cheese, in which their U.S. company, namely Belgiosol, Arthur Schumann, Saputo, Satori, or Swiss Valley Farm are using as a generic name. And we, at that time, we have to refer exactly what the EVFTA represents. However, now the problem is how to define the term actually commercial use in good faith. And as you know that in Vietnam, the law system is a civil laws and all have to be based on the written law. Then this is also to be, this system is also to be considered to be further clarified in domestic regulation to implement this exception more effectively. The text for Feta exception is similar to the previous cheese, with the time frame also is prior to the 1st January of 2017. The action is cover the actual commercial use in good faith in Vietnam. The only difference is using this indication for the product of cheese from sheep milk or sheep and goat milk. The third, the exception for the group 2 for champagne. This is also rather similar to the other exception, in which for the transitional period of 10 years from the effective date of EVFTA, which is 1st of August 2020, the protection of champagne shall not prevent the use of champagne indication or its translation, transliteration, or transcription in Vietnam market if actually commercial use in good faith for the right of wine. In preparing for that, especially for Vietnamese company, on every Evfta propaganda seminars and conference, the exception usually become one of our topic to guide and warning also the Vietnamese enterprise in their import activity of champagne sparkling wine to Vietnam, so they can be well prepared before ending the transitional period in the EVFTA. The third provision I want to refer to is about the mechanism of amending the GI list in EVFTA. Based on the regulation in EVFTA, there are three issues raising here. One, a GI of the list can be removed out of the list if it is ceased to be protected in the country of origin. This is also reflect one of the main rules that's also referred to in GI section, so that the parties shall not oblige to protect a GI which is not or cease to be protected in the country of origin. Second, a GI can also be added if on the date of signing EVFTA, this GI is not registered as EU GI and satisfied the EVFTA procedure, including oppositions and examinations. As for the note from the negotiators that we have met, this regulation mean that if the new member join the EU, this member's GI can be, in principle, added to the list. And it's for the third. However, all the amendment, including remove or add GIs, must be done through the mechanism of EVFTA amendment, in which the working group of IPR, including GI, will prepare a recommendation to amend the list, and the final decision is made at the level of approving the agreement, that is Parliament. The fourth provision is about the GI enforcement. Unlike the enforcement requirement of other IP subject matter, which mainly refer to the civil action and border measures, GI has like a kind of special treatment provision when it has additional article beside a separate section for enforcement, in which the administrative action is referred as an additional measures to prohibit a person from manufacturing, preparing, packaging, labeling, selling, or importing or advertising food commodity in a manner that is false, misleading, or deceptive regarding its origins. I may say that this requirement seems to extend the GI protection to administrative measures compared to TRIPS. However, I see that it is seem to fit our legal system of Vietnam, which is still be based mainly on the administrative sanction that Dr. Vivian is referred to previously. And for the border measures, the protection of GI in EVFTA is also considered to be extended more than TRIPS, since this counterfeit GI good is added and together with the counterfeit trademark good to be the good infringing IP rights and must be under control of the custom authority to take systemic action in respect of import or export good. Based because of those outstanding provision on GI in EVFTA. So in order to comply with the EVFTA and also to meet the practical needs of the Vietnam development, our IP law is under the revising procedures, in which there are four main issues related to GI will be revised at this time. First, it is owner of GI. Currently in our IP law, the owner of GI belongs to the state, and the state authorizes the local community to administer GI. This policy is placed to ensure that the GI is managed in a proper and equal manner to other producers in the community, since management of capacity of the local community is still a problem in Vietnam. But now the new approach is proposed in a way that the owner of GI should be the local communities of that GI, and that community should be responsible to the quality reputation of its own GI, and the state only play a supportive role in the managing that GI. Two, the GI user registration. Currently, Vietnam IP law requires that the community should register the list of GI users to IP office in order to manage who can use GI. But now, under the requirement of Evfta, the new proposed provision will leave the management of users to the GI community to decide without obligation to registration to the IP office. Three, the regulation related to the homonymous GI in our revised IP law basically will be based on the Evfta instead of missing right now. This regulation proposed will require the homonymous GI should be used in a way that differentiates from each other and would not be registered if misled the consumer. And finally, the conflicts between GI and trademark is being proposed, including the provision of revocation of registered trademark if the use of registered trademark in respect of goods or services misled the public as the nature, quality, or geographical origin of those goods or services. So the quick review of the GI provision and the proposed revised our IP law. We just figure out some areas that can benefit from the Evfta in respect of GI provisions that follow. First, for the area of GI regulation system. Like the EU, Vietnam has sui generis system of GI protection, and thanks to the Evfta, the legal base for GI regulation now is more adequate and effective, meeting the EU level protection standard. Based on that, the agricultural communities across the countries have more means, more tools of support in a way to enter a big export market like the EU. And the adequate and effective legal system of GI also create a creditable business environment, again, attracting more and more enterprises to come to Vietnam to invest and do business, especially in the agricultural sectors. Secondly, for the GI products of Vietnam, with 39 GI protected in EU through FTA, the cost and time of GI registration was remarkably reduced. One of the cases we can recall is about the registration of Phú Quốc Fish Sauce or nước mắm Phú Quốc, even with the support of EU project, it took, I don't remember exactly, but more than 2 or 3 years to register in EU. And now also the process of Evfta negotiation rather long, but however, compared to the time if you have to register 39 GI one by one, then the benefits of protecting GI through the FTA is really help. Other benefits to the Vietnamese GI, including the strong protection for fruits and nuts, which is the main export product of Vietnam to EU. With the GI protected together with the quality, these products can potentially be exported with higher price, and when they have their position in the EU markets as the Vietnamese specialties, they can create an opportunities to other Vietnam agricultural products to be present in EU as well. Here is some quick statistic of the Ministry of Agriculture and Rural Development of Vietnam. Since the effective date of Evfta, overall value of agricultural products export to EU in August and September reached the number of 711 million US dollars. And compared to the export values in July, before the Evfta, the export value in August raised 16.6%, and in September raised 20.3%. Among the agricultural product export to the EU, fruit and vegetable in August also reached the number of 14.7 million US dollar, rising 25.2% compared to the July export, which mainly the pomelo, dragon fruits, or coconut. Coffee also the main export to the EU, and the quantity export to the EU in August, the value reached 76 million US dollar, rising 34.7% compared to the July. And EU now is the most coffee consumer of Vietnam, with 40% of export quantity and 38% of export turnover, overall export turnover. However, we must admit that the opportunities always come together with the challenge. Although the door is open for Vietnamese agricultural product to EU market, but to actually enter into the EU is another story. GI protected in EU is just a kind of chance to be there, chance to introduce the Vietnamese specialties to EU, but the ticket still to be paid as a number of certifications such as the safety standard and quality, organics production, plant health and phytosanitary regulations, marketing standard, etc. For Vietnamese producers, all of these requirements are still strange or unknown or not familiar. And in order for the GI product to meet all the needed certificates, financial investment is really a big problem that has to be solved. However, we see that the more challenges, the more opportunities. At Evfta, we see that it's a chance to upgrade our agricultural economy to the new level, step by step integrating into the global economy.